Biafra. Nnamdi Kanu's lawyers write Malami, Foreign Affairs Ministry, and make demands. Welcome to the news and please subscribe to our channel. The legal team of Nnamdi Kanu, leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, led by Aloy Ejimako, has written to the Attorney General of the Federation, AGF, and Minister of Justice, Abubakar Malami. The team is demanding Kanu's unconditionally release in line with the recommendations of the United Nations Working Group on Arbitrary Detention. They reminded Malami of the need to accord Kanu an enforceable right to compensation and other reparations for his continued unlawful detention. The letter was addressed to Malami, and the Minister of Foreign Affairs was signed by Chukwuma Machukwu and Ejimako. The letter reads partly, as he must have noted, the opinion demanded the government of the Federal Republic of Nigeria to immediately and unconditionally release our client, Mazi Nnamdi Kanu, and accord him an enforceable right to compensation and other reparations for his continued unlawful detention. The working group requests the source and the government to provide the above-mentioned information within 6 months of date of transmission of the present opinion. However, the working group reserves the right to take its own action in follow-up to the opinion if new concerns in relation to the case are brought to its attention. Such action would enable the working group to inform the Human Rights Council of progress made in implementing its recommendation, as well as any failure to take action. All emphasis ours. Your Excellency, we are sending this demand letter to you because we believe that the subject matter falls under the jurisdiction of the Foreign Relations Ministry of Nigeria, as it is the duty of the ministry to, among other things, ensure that Nigeria complies with obligations under international law. Thus, in your consideration of the subject matter of this letter, we respectfully invite you to be guided by the following. The working group, which is an integral part of the United Nations Human Rights Council, is a quasi-judicial body that has the legal mandate of the United Nations to adjudicate human rights petitions brought against member nations of the United Nations. The opinion of the working group is legally binding on Nigeria because it is based primarily on universal human rights, standards set by Article 9(1) of the International Covenant on Civil and Political Rights in 1966, the Universal Declaration of Human Rights, Universal Declaration of Human Rights in 1948, the Body of Principles for the Protection of All Persons under any form of detention or imprisonment, 1988, the Declaration on the Protection of All Persons from Enforced Disappearance, 1992, the Principles of the Effective Prevention and Investigation of Extra-Legal, Arbitrary and Summary Executions, 1989, all to which Nigeria is a signatory. Some of the above human rights instruments were mentioned in the opinion as having guided the working group in reaching this decision. To be sure, ratification is the means by which a nation renders itself subject to international laws and treaties, and by virtue of Section 12 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and a plethora of decisions by the Supreme Court of Nigeria. Ratification makes Nigeria subject to and bound by whatever treaties, principles, protocols, etc. that is ratified and domesticated. Thus, Nigeria's domestication of Article 6 of the African Charter on Human and People's Rights, which includes Article 6 that guarantees the right against unlawful detention. This article is as well very similar to Article 9(1) of the International Covenant on Civil and Political Rights, has made Nigeria bound by it and in extension bound by the opinion of the working group which it was founded on. Furthermore, the International Court of Justice in its dictum in the hostages in Tehran case ICJ reports 1980 42 PARA 91 held. Wrongfully to deprive human beings of their freedom and to subject them to physical constraint in conditions of hardship is in itself compatible with the peoples of the Charter of the United Nations, as well as the fundamental principles enunciated in the Universal Declaration of Human Rights. It thus follows that, notwithstanding that the states may not have ratified or otherwise adhered to any of the preceding human rights treaties, it is nonetheless bound by other legal sources to ensure a person's right to respect for his or her liberty and security. That Kenya has not taken up a complaint against Nigeria for kidnapping a British citizen in a sovereign state cannot in law be an alibi for Nigeria so as to avoid its rule of law obligations. The case of the United States, thus Kanu, also cited in the opinion, emphatically points out that the violation of international law is not merely a political matter to be settled through diplomatic channels by the states involved, but can also be relied upon by the accused at the domestic courts. To this effect, even when Nigeria denies being a signatory or to rectifying some of the instruments as listed above, which the working group relied on, the International Court of Justice has already set the precedent that even state that you do not ratify those documents, you ratify this document will still be bound by them. As a bona fide member of the United Nations Organization, Nigeria is subject to decisions, opinions, issues from all the United Nations bodies. Thus, it is our firm position that Nigeria is legally bound to implement this well-founded and universally respected opinion in its fullness of letters and spirit, and it is expected to do so promptly. The Committee of Nations cannot allow Nigeria to pick and choose benefit from international covenants and conventions to revile on its duties and obligations accruing from the said international covenant and conventions. For her benefits, Nigeria followed through with her claims over Bakassi in the International Court of Justice. How did we come to this level? In fact, we must reiterate that impunity and violence are sure signposts of misgovernance are never allowed in the Committee of Sovereign Nations, where intelligence, higher thoughts, and diplomacy are the only life wires of good governance and mutual international relationship with other nations. Alright, on this note, we have come to the end of the news. We say thank you for tuning in to listen. Until I come your way next time, enjoy the rest of your day.